Sorry, I'm back. Okay, so that was learning outcome 2, and then we have learning outcome 3. So learning outcome 3 is, as mentioned earlier, to organize a range of legal documents. So for instance, when we speak of legal documents, can you imagine if you would like to sue a defendant in the court, there are a lot of documents that you need to prepare as a lawyer. But of course, in truth, the lawyers will not prepare these documents. These documents are prepared by paralegals. But nonetheless, as a law student, you must be familiar with these documents. For example, you need to have writ, you must have statement of claims, there must be statement of demands. All right, so these documents must be prepared basically, okay? All right, then the next is again learning outcome 4. So sorry, that was 3, and this is learning outcome 4. So this is to look at how the legal practice has evolved over the years. This is where I told you we'll go through the law technology, and I know by now you have done a lot of reflection, right? Correct? So here also, part of your assessment, you've got reflection, but it's just a short reflection, not very long. Okay, it's an important aspect, but not the main focus of your assessment. Okay. All right. So this is your assessment. Assessment 1, you have 3,000 words essay. It carries 50% weightage. Okay. Assessment 2 is will drafting. Word count is 1,000 words, and it carries 25% weightage to your final grade. Assessment 3, skeleton arguments must be prepared, 20% weightage. Reflection is only 500 words, and it carries 5%. So all these marks will be consolidated. Your total grade, if you pass, that's enough. Do you see here? All right. So you have actually quite number of work to do for this assessment. Hence, our course is until September. Okay, guys? All right. Now, let me take you through assessment brief 1. Okay, we have this here. Assessment brief 1. So this is the 3,000 words essay. This is the essay question, which is already given to you in advance. So look at the keywords that you have. You must write an essay, and remember, the expectation is to critically analyze. What is the meaning of critically analyze? It means that your arguments must be evaluative. You have to analyze the current position of the law. Not only you must analyze the current position of the law, you also have to propose recommendations. See, recommend the strength and weakness of the current law. So which means you got to be very, very evaluative. You know why you have to be very evaluative? You are in level 6. This is your finals. So when you're in your finals, it's so important for you to come up to the standard of a level 6 student. Don't worry, I'll teach you how to do that. Let's look at this question. It's a quote, and then you have a question. The quote says, the meaning and scope of legal aid has been altered with the enactment of this 2012 Act. There are now many areas of civil law outside the scope of legal aid. Basically, the quotation criticizes the 2012 legislation by saying that there are many litigants who are unable to claim for legal aid because of the reformed law. So this 2012 law is the present law. So you have to, maybe you can start doing independent research. You have to start identifying the criticisms, the strength of this 2012 Act. Doing advanced independent reading on this legislation would not hurt, right? So now if you look at the question, it says that, firstly, discuss the changes introduced by LESPO and then you must analyze the consequences. So analyzing the consequences is where you are going to discuss the pros and the cons of this 2012 legislation. All right? Then a good student, you want to score 70%. You want to get first class, you have to do something which is not directly in the instruction. You have to find proposals to strengthen the current law. So this is something that I will not take you through. You have to do your research because it's a research essay. Research essay means besides what is taught in class, you got to show that you as a law student have done independent research, and you must show me your independent research in your essay. So when I read student A, student B, student A has given me a lot of proposals. So I know this student has done independent research, hardworking student, well-read, very good understanding of law. Of course, that student will get 70. Do you see here? So for this level, I'll give you the basic information. But as you see, it's research essay. You have to use access. You have to make use of your access to the online library. Do you all still use your Westlaw LexisNexis? Do you all use? I'm not going to ask you the question whether you have access or not, because you all must have access. Okay? So make sure you do not rely on Google. You have to go and search on online legal libraries, published journals, published articles. Okay? And then that's 2005. Then what is the remaining 500? Because your learning outcome deals with UK system and Singapore system, all right? So what you have to do here is you must identify and summarize the legal aid bureau application process for legal aid and assistance in Singapore. This one is 500 words. This one is just descriptive. I repeat again, this 500 words essay, this part is descriptive because the question says identify and summarize within 500 words what is the application process. That's all. Okay? Now, so in total, it's 3,000 word count. Also, please take note that you are going to follow OSCOLA referencing. Okay, you're going to apply OSCOLA referencing. When you apply OSCOLA referencing, do you all have the OSCOLA referencing handbook? Was it given to you through any other subjects before? Everyone has? Okay, I know Prince cohort will have. Lucas cohort. What about the other cohort? Shin, what about your cohort?
No, I don't think we have it.
You don't think so? Okay, so what I will do before we end the session, I'll just upload that on my Google Drive and I will immediately share it with you. It's a 68-page book, all right? So there's very detailed guidance on your OSCOLA referencing, but we won't talk about it today. Perhaps I'll just take you through the OSCOLA referencing on another day. Okay, when we do essay questions, then I'll take you through them. Okay, now that we have seen this assessment 1, I need all of y'all to read all of this. Okay? Now, Kaplan would have given you this date here, right? Is yours filled in? Is your date filled in here? What is the date given to you? 22nd October for summative 1. Okay, thank you. So yours will be 22nd October, and you must submit this on Kaplan LMS as usual and stick to the date given in timetable. On your canvas, the time and the date given to you will be different. Okay, so when it's different, it's because sometimes students will submit late, they'll be late submission, right? So don't follow the canvas time, follow the time given to you by Kaplan timetable, okay? So I want you to read the rest of the materials here. Please take note, plagiarism is an offense. Okay, no plagiarism. So when I say no plagiarism means you must ensure that you paraphrase. No, don't put quotes, long quotes. All no marks will be given to me. You're not going to impress me or the professors in university, because here we want to test your understanding skill. So it's important for you to write it down in your own words. Okay, if you have any issues with regard to plagiarism, you can speak to me personally after class, during the break, or so on. So make sure you read through all of this. Okay, and in terms of marking guides, there's some guide given to you here as to how you must ensure that you have a proper structure. Just read all of this. What will be a first class answer, second class answer? So all of this have been prepared for you. So if you really want to do well in this assessment, you have to read all these materials. Okay? When we answer seminar questions, workshop questions, of course, I will show you how to prepare coherent arguments and structured answers. Okay, so that's for summative 1. Now, let me take you through summative 2. Okay, so this is summative 2. Okay, summative 2 is very interesting. I will say summative 2 is no-brainer. It's a way to get you to pass your assessment, okay? But of course, it carries only 25%. Remember that. This is the situation given to you about Benny. Benny wants you to draft a will for him. Benny has shared with you about all his estate, his properties. Okay, all of this have been shared with you. You must prepare a draft will. That's all. And if you are thinking, but how to draft a will? When I go through the wills and estate lesson with you, you will see there's a template given to you. To be honest, to me, this assessment is just a matter of constructing in English language. All right? So if you really look through this content, you use the template very well, you can definitely, all of you will pass this portion here. Okay, so that's your assessment 2. Assessment 2 also will have to go through Turnitin. So when you look at this information, right, his son, for example, his son Sam to benefit from the residuary estate. You can't just copy this and put it in your will template. You must write in your own words. It will not make sense if you just copy this whole thing and put it in the will template which have been given to you and say, okay, this is his will here. You have to ensure that you construct. So I think it's just a language exercise. Okay, that's assessment 2. Then the final one is assessment 3. Okay, I know some of you all are quite curious to know what is assessment 3 about, right? So assessment 3, we have moods. So this case have been given to you. This is a thought case. Okay, so you can take your time to read this. We won't go through this scenario now. When I do my mooting class with you, I'll guide you through the facts. Okay, but let me tell you what must you do. So as you can see, this case was decided in the court of first instance. What is the court of first instance? It means that it went to an English court. And why we call this court of first instance? Because this is the first court to decide on this case. It could be the county court in England. It could also be a high court. Okay? So this is what Justice Cleese found. Then, what happened now? There's an appeal, you see? So now you have to present your client's case in the appeal court. Who is going to be the claimant? Who's going to be the defendant is something that I will allocate. Okay? In my negotiation session, I thought both groups, I think, right? I thought Abulim and Azira. Yes, all of y'all I saw for negotiation. I didn't have any problem, right? I want the same. I will allocate you randomly, and I hope full cooperation from all of you. No, different groups are big. what I say, I'll allocate randomly. But I'm saying back then I did not have problem. I hope the same thing. I don't want to have any problems here, okay? We are all adults. All of you all have one purpose, which is to pass your assessment and graduate, right? Let's just stay focused on that, okay? Okay, so if you look at now, how will you be tested on your mooting? So for your mooting, you'll be tested in this way, okay? So you and your client must present the case in an appeal court. So this is where you'll be brought to Kaplan. You'll be brought to Kaplan. Yes, I'm going to be your judge. It's either me or Vijay will be your judge. Either one of us will be your judge. It's a mock court. Mock court means it's a courtroom environment. You have to pretend that you are a lawyer and you have to present your case. All right? Then, when you are presenting it in the Court of Appeal, not Singapore Court of Appeal, but UK Court of Appeal here. So, here we have some structuring your introduction. I've incorporated all of this for you. Court etiquettes. I'm not going to go through these details now. When we do mooting lectures, I'll take you through all of this. But you can read in advance how to address the judge. All of these have been given to you. How to address other counsel. Okay? When you read a case in the court, you must read with a full citation. See, all these samples I've given it to you. So, it's very easy. It's just a matter of presenting only. Okay? So, how are you going to be assessed here? For your presentation in the courtroom, no marks are awarded. So, then I know you will say, okay, then I don't have to present in moots. But unfortunately, you have to do a reflection on your presentation. Your reflection is on your mooting presentation. You know the 500 words reflection? Like how you did for negotiation, you're going to do the same thing. Okay? So you see your assessment here. Firstly, you must prepare a submission. This submission is graded. Okay? So your submission is graded. And this is where it's 1,000 words. That's the skeleton arguments. Then you must prepare a reflection. This reflection is 500 words. This is also graded. So your mooting, you're graded based on your skeleton arguments that you prepare and you upload on Canvas, and your reflection based on your presentation. Do you see here? So therefore, technically, participating in the moots is mandatory, otherwise you cannot do your reflection. Do you see here? Okay? Like all assessments, you have 10% plus minus. 10% extra word count, 10% less word count here. Okay? All the skeleton arguments, this reflection must be based on your own word count. Take note of your deadline given for mooting, the wills and draft here. Please read the other instructions. The plagiarism instructions are same, all right? And what are the intended learning outcomes here? Okay? So now you tell me, are you clear with the methods of assessment? Do you have any questions that you would like me to address about your assessment? Take your time, go through the documents. Let me know if you have any questions. And if you have questions, don't worry, don't be shy, because as I always tell my students, your questions will benefit the rest as well. And the ladies, why are you all hiding all your pretty faces, Azira? Why are you hiding your pretty face, Azira? You can turn on Azira, right?
What is?
Even if she don't use makeup, she's very pretty, you know.
Thank you.
And then, who else do I have here? Kushbu, you also hiding from me?
I'm not hiding. I'm still working. I'm like multitasking.
Sophia, what about you? Sorry, guys. Let me just give some attention to the ladies, okay?
I'm sick right now.
And Shin, you can also turn on your camera, so at least I can see your pretty face and I'll be motivated to lecture. So for assignment 2, the submission. We didn't want to take the attention away from Jason. See, when I'm bored seeing Jason's face, I can see yours. Okay, let's see what Jinling has asked me. So for assignment 2, the summation of skeleton arguments is before the mooting or would it be after? Look at your deadline. So your mooting date will be given to you and it's usually, I can't confirm now. I need to check with Kaplan on that, Jinling. I know assignment 3. I think it will most likely be after, but let me just confirm that once again, the mooting date. And what is the submission date given on your timetable? Did they give you a particular date? I'll write this down in my notebook. Is there a date given for you for submission assessment 3? So the 22nd October is for assignment 1, right? For 2 and 3, is it the same date? Can you help me to check this? For assessment 2, what about assessment 2? 22nd, okay. So I will just check for you on assessment 3, I can do that, okay? Assignment 3, the submission date for the reflection and the skeleton argument. Okay. I'll inform you by the next class. Thanks, Jinling. Even I didn't notice that, yeah. Anyone else with any other questions? No. Okay, even if there is, of course, you can always ask, right? Okay. Now, let's start with our first lecture, which is on the English and Singapore legal system. Okay? It's been so long since I taught this topic, the legal system. Okay, so what are we going to go through this topic here? In this topic, you're going to appreciate the meaning of legal system. I will explain to you what exactly is the definition of legal system. Then this is the historical part. I will explain to you the history and the development of the common law system in UK and Singapore. The reason why it is mentioned as England, there's a historical reason behind it. If you actually look at the English history, Scotland, Ireland, and then you had Welsh. So the monarchy, they had wars among themselves. So for instance, there were points where England didn't have king. So they invited the kings from Scotland to take throne for Scotland and England. So they have their own history, like Singapore, Malaysia history, for instance, right? So the common law system actually originated in England. So that's the reason why specifically it's England. Don't think it's a mistake that, it should be UK. The Scottish system is slightly different. So that's why it's always called the English legal system. When you look at textbooks, okay, the title of the textbooks are usually English legal system because the Irish, Northern Ireland and Scotland, they have different system, very different from England, okay? So we in Singapore, the Commonwealth countries, we actually follow the English system, okay? And then I will also highlight the features of the common law system. So as I discuss the features of the common law system, we'll talk about case laws, judge's role, and so on. Okay? So let's start with the first learning outcome, which is the the definition of legal system. Okay? So when it comes to the definition of legal system, this is where we are looking at a legal system is generally described as procedure or process. Okay? It's a procedure or process. And what is this procedure and process for? This is a procedure and process for interpreting and enforcing law. So let's just take some time to digest on this. When I say these are procedures and process to interpret and enforce laws, let's just try to apply this to our Singapore context. In Singapore, who interprets the law? Can you tell me in Singapore, which institution has the function to interpret the law?
Judiciary.
Very good. No, not the law society, it is the judiciary. Whose answer was that?
Fine.
Okay.
Okay.
So here, when it comes to the judiciary is the institution where will give a final interpretation of law if there's any dispute, conflict with regard to the legal interpretation. Okay? It's not parliament, it's not the executive. Parliament's function. What do you think is parliament's function? What is parliament? Very good, Amelia. Parliament's function is to make law basic. Correct? That's what Amelia used the term enact law. Now, when I say that Parliament enacts law, judiciary now will interpret the laws. So therefore, we have a system, right? Okay. Let's talk about Saudi. Let's talk about the Middle East. In the Middle East, which institution dominates or has a key role in playing all these roles?
Monarchy.
Very good, yes. Do you know in the Middle East, the monarchy still plays a dominant role? We don't have to go so far. Look at Brunei. Brunei is the same, right? The monarchy is so powerful, they get to pass laws. I don't know. So, in that context, do you see, if I remember watching a documentary about Saudi. In Saudi, the women will queue up in one location, the men will queue up in a different location to meet the king. And this is like the ancient times. They will petition all the ingredients. They wrap it in a paper, long paper, A4 paper, wrap it. I saw in the documentary, then they give it to the king. And then the king will collect it, then the king will give it to his ministers to look into it. That's an ancient thing that we used to do in many monarchical systems. So do you see their system, their legal system is different. The way how they enforce and interpret the law is so different. So this is how you need to understand legal system, the processes and procedures can be as such. There are different types of legal systems in the world. Different countries have got different legal systems. The most common two types of legal systems that we have, okay? The two common legal systems are number one, common law system, number two, the civil law system. When we speak of the common law system, I know that judge-made laws are generally known as common law, right? But the word common law has got another meaning. Common law system means we're talking about the system itself, the proceedings. Okay? Civil law, I know, is generally classified as private laws, but I'm not talking about the laws, I'm talking about the system. The term that we use is same. Okay, so we have common law system and okay. Now let's look at the quote by Mary Menkier about the various systems around the world. So let me enlarge this. So here he basically says that legal system is described as a legal tradition. You see the word used here, legal tradition. Legal tradition, the word tradition. You know why we use the word tradition? Because the legal system that you adopt in your country is based on the country's tradition. There's a cultural influence. There's not only a cultural influence, there's also the society's role is important. Okay? So that's in terms of we use the term legal tradition. Next is when we use the term legal tradition here, okay, now you understand why sometimes in books they use legal tradition. It means that it's not rule, it's not about law. We're not talking about, when they say it's not a set of rules of law, means when we speak of legal system, we are not referring to, okay, when we speak about the legal system, we are not referring to your criminal law, contract law, tort law. We're not referring to the substantive law. System means we're talking about the due process here, right? We're talking about, you look at the third line, rather, it is a deeply rooted, historically conditioned attitudes. That's what I say. That's the reason why I say we use the term legal tradition. Because we must look at the history of the country. Singapore, for example, our system is based on the English legal system because we were ruled by the British. British rulers, okay, they incorporated the system here, and when they left, we just continued. China, for example, I know people, we used to say it's a communist system, but it's no longer a communist system. The system has changed, right? So there will usually be a turning point or historical reason as to why a country adopts a particular system, okay? And then the system here is about the operation of the legal system and how the law must be made. So when we speak of legal system, it's a procedure, there are procedures, right? So the system will tell you how laws must be made, how laws must be enforced, who can interpret the laws, alright? That's the idea of legal system. So whenever somebody comes and asks you, what is the difference between legal system and law? So you must explain, law are set of rules. Legal system is about how does the system govern the enactment of the law, the interpretation of the law, the enforcement. We must have a system, right? For example, to put this in a very simplified manner, let's say you're working in a company, let's say you're working in an event company. So the main purpose of your company is to organize events, right? So let's say your company is very good at organizing events for more than 10,000 people. But you must have a system, right? System, it means if let's say you have a client, step 1, step 2, step 3. This department is in charge for A, this department is in charge for B. So all departments come together and now the event can successfully take place. So the legal system is like that. The legal system will say that we have got parliament, we have got judiciary, and we have got executive. Okay, so take note of the 3 pillars of the state. So the 3 pillars of the state. Okay, number 1, we have parliament. 2, enact law. Number 2, we have executive. Executive's function is to administer laws, enforce laws. So who will be part of this executive? Ministers, enforcement officers, all of them will come under the executive branch. Civil servants, all of them will come. Third, of course, we have the judiciary, and when we speak of the judiciary, is to interpret laws. And of course, to resolve dispute. So that's the system that we generally have. Can you think of a country without any one of these institutions? Can you think? Don't have, right? Correct. Interesting. What's the Mauritius Maldives system, huh? What is their system? Yes, and isn't North Korea too? What kind of system we have in North Korea, Edison? But Mauritius, we have ministers, one. Sadiq, why do you say it doesn't have these institutions? I think they have courts, they have parliament in Mauritius and Maldives. North Korea, Of course, it's a supreme leader, right? Vatican, yes, correct. The Vatican City itself. Okay. See, you see, different countries have got different system. And you look at Vatican, for example, it's historical because of history, right? Their tradition, right? North Korea, again, you look back at history. Okay, now that you get an idea, I hope you understand what I've explained. Okay? Saw a clip in Facebook on either Mauritius or no police force or no armies. Not sure about that, Sadiq. So now if I were to ask you to interpret, what is your interpretation of this code? In 2 or 3 words you can share. You can either unmute and speak to me, or you can actually type your answers in this chat box. What do you understand? Don't understand anything. At least give me one keyword. Where's Jason? Jason, are you here, Jason? Are you still here? Jason's also gone over here. I'm left all by myself alone. Constitution. I never spoke anything about constitution here. In this code, there's no reference to constitution, right? What else? Just look at this code here. Someone wants to say something. Cultural perspective. Okay, so Amelia is trying to say the legal system is rooted to the culture of the society. Correct? Would you all agree with Amelia? Yes or no? A, yes, B, no.
Yes.
Yes. Do you know, I'm at the moment, I've enrolled for a short course. That short course, the trainer ensures that we all turn on our cameras. And then we all have to participate and give answers. I should do like that trainer. Make sure that all of you all turn on your camera. Now it comes. Did you cut your hair, Shin?
But it has already grown longer, so you're not seeing me for quite a while. Yeah.
The legal system reflects how the society evolves. Okay, Ken, that's correct also. Lucas, Amelia, you used to turn on your camera, right? What happened to you? Next week, okay. I'll wait for you next week. You all can take turns to entertain me. Okay, now let's move to examples of various legal systems that we can possibly have in a state or in a country. Okay, so common law system, civil law system, Sharia system, supranational system. Let's talk about supranational system. Okay, actually, before discussing supranational system, can I just give you a brief description of all the systems? Okay, common law system is a system which allows judges to make laws. Okay, so common law system. Are you all looking if I were to type the brief description in the chat box? Because if it's in the chat box, you can always look at it. If I type it on my slides, then I will have to move on, right? Okay. So when it comes to common law system, it empowers judges to legislate. So technically, there is very minimal separation of powers between parliament and judiciary. Okay, this is a system which allows the courts to make laws, develop laws. So there is weak separation of powers between judiciary and legislature because of this. Legislature is basically parliament. Then if you look at the civil law system, to give you an idea of the civil law system is a system where there is strict separation of powers. And when I say there is strict separation of powers, why do I say there is strict separation of powers? Because in this system, okay, the judges must resolve disputes based on the laws enacted by Parliament. So whatever laws enacted by Parliament is final. Okay, the laws can all be found in written form, which means either in statutes or codes. So there's clarity here. So it is very, very different from the common law system. Because common law system, when judges make law, you cannot find it in statutes, right? Correct? In common law system, some of the laws are made by Parliament, some of the laws are made by judges. So when it's a combination, there's no proper clarity, not so structured like civil law. Civil law is super structured. Okay? Countries like Japan follows the civil law system. Do you know our neighboring country Indonesia also follows the civil law system? Okay? Then we have the Sharia system. The Sharia system is, of course, based on, I wouldn't say it's based on the Quran. Sharia law is separate from what you find in the Quran, although many has argued that the Quran is the basis of the Sharia law, right? But of course, this governs Muslim affairs such as marriage, right? Even family disputes, estate distributions. So in Singapore, we also do have the Sharia law, and it governs the Muslim affairs pertaining their marriage, family disputes, estate distribution. But in other countries, like the Middle East, even their crimes are regulated through Islamic law. So that's very different. Their system there is very different. Okay. Now let's talk about the supranational system. Supranational system is so sophisticated. Supranational system is like a business entity, the organization. This is where EU is sovereign and the member states must loyally accept the EU laws. So the supranational system means all the member states will have equal standing. EU is above them. Whatever laws which are passed by European Union, it is mandatory to be applied in member states. So they got 27 member states. All 27 member states must follow whatever EU laws is. That's the supranational system. So European Union creates a supranational. One person, the institution is above. All other states must comply with the rules based. Okay? So when we speak about this sovereign system and loyally accept EU laws and so on, so bear in mind that there are many different types of legal systems. So when we have many different types of legal system, you need to bear in mind, okay, you need to bear in mind these legal systems here will vary according to the okay? Now, let's talk about, so we are done with the first part, which is to understand what is a legal system. Okay? So now that we've seen what is a legal system, the next is for us to look at, we want to focus on the English legal system. The English legal system is based on the common law system. So that's how you refer to it, okay? So the English legal system is based on the common law system. So the system itself is called the common law system. So in other words, the Singapore legal system is based on the common law system. Okay, so like I said earlier, England is the state or is the country which developed the system. So, but what is the name of the system? Is the common law system. Okay? So I want to now explain to you, before I explain to you the features of the common law system. Okay, before I can explain to you the features, it's important for us to appreciate and understand the origin of the common law system. Let's go through that first. Like how 1963 and 1965 are significant dates in Singapore. 1066 is also significant in England. Why? Because this is the historical moment. This is the start of the Norman conquest. What is the Norman conquest? This is a type, you know, when you look at the royal history, they're not pure English people. We've got some French involvement. That's from 1066. Okay, I'll tell you what happened first. Before the year 1066, the Anglo-Saxon society, they are a group of migrants. Okay? They migrated to England. You look at the year they migrated, 400 KD. So this Anglo-Saxon society migrated to England and they created their own powerful kingdoms and society. Of course, their kingdom, their king here, all right, they created a very sophisticated, very, very technical, complex of system of governance here. Today it's so simplified. But the main purpose of kingdoms back then, you must appreciate and understand, is to create, is to collect tax. That's the main priority. Okay? So when you look at this Anglo-Saxon society here, the king developed the society based on customary laws. Customs were the rules of their lives. Okay? They will follow customs. So for example, if it's a customary practice for a boy to go and work at the age of 14, you have to go and work at the age of 14. So there is no logical basis of their law. They purely follow customs. What is the meaning of custom? Your custom is developed based on your culture. Your custom may have the influence of your religion, but it's very different from religion. Alright? For example, yeah, Prem, that's absolutely right. It's your social norms. For example, I can speak about a custom that I know lah. Hindus in Singapore, Malaysia, has got similar customary practices. Hindus in India, especially in rural areas, their customary practices are different. Hindus in Bali, their customary practices are different. But they all pray to the same God. But the way how they pray, very different. So that is how custom is different from religion. Right? So it's the society's rules like what Prem has suggested here. Okay? So the Anglo-Saxon society is governed by the customary practices mainly. So let's look at their customary practices. When a person is at the age of 12, you must take an oath that you will not be involved in crime, and if you know that anyone who's involved in crime, you must report. That is the meaning of this custom here. Today, do we take oath? No, we don't take, right? So we want obedience. Do you see? That's a good social norm, but they do it like that. So basically, the responsibility is on you to ensure that your community and society is safe. So the Anglo-Saxon society creates a society, a responsible society, And you have the burden to live in a safe society here. What if now the oath is broken? What if now someone is involved in crime? So here, this person will be labeled as disloyal, not an honorable person. Family will be punished. Not you know, the family can be punished. The whole family will be forced into exile. These are things that we read in history. But you see, this is the year 1066. Okay? The victim's family can claim for compensation. And of course, if the dispute is not settled, look at what can you do. You can seek revenge. Seek revenge means that actually a war, a family feud, and it will go on and on and on. Like after one family, the next family, the next family. So these two families will have rivals like for like donkey years. Like watching movies, right? That's the Anglo-Saxon society. Just based on human emotions. Okay? Can we blame them? No. That's the mankind at that time. Compare yourself 20 years, maybe you're not that old, maybe 10 years ago. The way how you think 10 years ago and the way how you think now is very different. Correct? The way how your children will think in the future is very different from the way how you think. Because mankind, we evolve. So we cannot underestimate the society. At that time, this was their legal system. Of course, now this is not appropriate. So that's why I love history, because I can relate to how the society evolves. So I feel like, wow, you can actually think about it at that time. But if that society will live in our time now, obviously the way how they think will be different, right? All right, so here they never had any real prisons because, like I said, it's a family feud now, right? So these two families can fight and so on here. So the punishment is basically okay lah. You still my goat, now come, I will punch you, I will teach you a lesson. So they never had a prison per se here. So that time the kind of punishment was like slavery. You're asked to leave the community, or in worst case scenario, there can be execution or other kind of gruesome punishment. All right. So, in fact, even at that time, there is no proper protection offered, I would say. Okay, even especially to women or children, the vulnerable people in the society. Then, over time, the Anglo-Saxon society, they came up with this idea called trial by ordeal. What does it mean? It means that if, let's say now, I come to the judge, the king, and I tell the king, Shin stole my goat. Now Shin says, no, I did not steal her goat. So, how do who's telling the truth here? So, for instance, punishments are, to see whether you're telling the truth or not, must walk on fire or red hot iron you have to hold. Whoever heals in 3 days, you're innocent. If you are infected, you are guilty. Right? See, that's trial by ordeal. Because we believe if you heal in 3 days, the God has chosen to protect you. But if your wound is infected, it means the God is upset with you. God doesn't want to cure you. So you are the victim, basically. Okay? So then what happened? William of Normandy, okay, from France basically, he declared war with the Anglo-Saxon society in England. So this war is known as the Battle of Hastings, such an important war. Like how we had the Japanese occupation, then the Japanese surrendered, all of that historical moments for us, right? This one is the turning point for the English history, right? So the Anglo-Saxon society was defeated by the Norman conquest, and William of Normandy, he declared himself to be King William I. Okay, he gave himself the title, he took throne, he became the King of England. those days, that's how you capture land, through war. Okay, so through war, he conquered the entire England basically. But now, William has conquered England, and these people who live in England, these people were used to follow the Anglo-Saxon customary society, right? How do I ensure that now they accept me as their king? How do I get their loyal support? That's an interesting point here. So he's a very, very smart man here. He needs to protect his kingdom from other armies and enemies here. So what he did was he strengthened his legal system. He made substantial changes to the church. The church was closely associated with the monarchy, and that's the reason why, if you look at the Church of England, it represents, or it advises, it used to advise the monarchy. So we do not want the church to be independent and influence the society based on some religious grounds. So he brought the church under his purview. And then, of course, when we talk about conquering a state, the justice system must be conquered, right? In any country, the justice system, the defense system is so important. So he worked on the justice system. So what he did, he modified, he tried to abolish all the Anglo-Saxon society system. He firstly abolished trial by ordeal within this time, gradually. It's not like a one-off thing. Gradually, they suspended. Then, that was done by William II. And then Henry II, who, took throne from 1154 to 1189, he created the jury system in UK. What's the jury system? So, basically, the king at that time has already created the King's Court. What is the King's Court? The King's Court means the king becomes the judge. If the people in the society were to have any dispute, you have to go to the king. The king will resolve your dispute. So, the king, under the Norman Conquest monarchy, they say we don't want to follow this trial by ordeal. And in resolving this dispute, the king basically, Henry II, he said that I want 12 commoners from the village, from the society to come and tell me what happened. So originally, the jurors are the individuals, jury is the system. The jurors were witnesses. But today, the jury, they will deliver verdict. I'll talk about the role of jury in our future classes. But for now, take note, the jury system was created. So they begin to create a structured system basically. Henry II also, he chose 5 members of his personal household, 2 clergy and 3 laymen to hear all the complaints of realm. So he started to create a system, a court system. And do you know what is interesting? Let me share something interesting here. Do you know when the king used to resolve dispute? The king, to show that he's superior, he used to take a bench and stand on the bench so that he looks taller compared to everyone. And that's how we got the name King's Bench Division. Today, in our courts hierarchy in UK, today is called the Queen's Bench because we have a queen. But that's the reason why it's called the King's Bench and Queen's Bench. And do you also know back then, because England is huge, you know the king used to travel around England to resolve disputes? And do you know the same practice is done right up till today, but not by the king, by the High Court judges in the UK? High Court judges are occasionally assigned to other parts of England for historical reasons. Right? So, when the king began to create this court system, that slowly, this is how slowly the common law court was created. So why did this king's court have the name common law court? It's a court created by the king, and if we were to call it king's court, we understand. But where did the name common law came about? Because they were already creating a system. These judges, they applied the same principles to all common people. So the same principles, they become a common practice, right? That is how the name common law developed. The laws, the rules were common to everybody. Okay? So a permanent court was created, like I said, the court of the King's Bencher. And then when you have proceedings, you go and meet the king. And meeting the king is different from meeting the king's council. King's council means like going to the palace, the king's council, where the king will have meeting, right, with his ministers. Then if there are disputes, you resolve there. But the court system was a separate court where he used to travel and apply the laws. Okay? So, like I said, the judges were ordered to travel around. So it came to a point where the king said, I'll just be in the king's council. I'm not going to be part of the court. Let all these judges travel around. So a system was being created. Judges were asked to be stationed at Westminster. You know the Westminster building that we have in London, the Westminster Parliament. So judges were stationed there, and these judges will develop new laws. How do they develop new laws? They will talk to each other and they come up with laws. Do you know that the practice still exists? If you were to do your bar course in England, in one of your course, you have to dine with judges. And when you dine with judges, you must have legal conversation with them. It's in the inns. You have to join and be in one of the inns of court. It's because of tradition, speaking about law in the inns. So that's how they used to develop law. So all the other judges who used to travel around the entire England, they used to apply the laws developed in Westminster. So a centralized system was created. The common law system eventually developed and became so common to everyone. Okay? Now, this common law system, now we're getting into the problem. So the common law system, before I get to the problem, the common law system became so popular. It became so popular because everybody now is happy. Imagine from the Anglo-Saxon society to this common law system. So developed, right? Correct? Like if you look at your maybe parents or grandparents, before 1965, they used to live in the kampong, right? Then in 1970s, everybody slowly started moving into flats. They looked at it as an upgrade. They were happy to move to the flats, correct? So because they feel like, wow, Singapore is developing and so on. So it's the same thing here. You lived in a society where there is no law, no rule, no prison, no judge. Suddenly everything is so structured, so systematic. You felt that because the laws were applied to everybody, the same laws, there's fairness. So you need to think about it. The strength of common law system is the same laws were applied to all. So when the same laws were applied to all, there is fairness. There is consistency. Correct? So that's when the same laws are applied to all. So that's how this was seen as the greatest strength of the common laws. Okay? But I'm sure you've heard of the saying, right? Whatever goes up will come down, right? Or you would have heard of the saying, there's two sides of the coin. So as the common law system became so prosperous, so everybody was accepting it, over time the system was becoming rigid. You know why? I'll tell you why it was becoming rigid here. There's a typo. This is not purchase of right. This is a purchase of writ. See this one here? Wait, okay. This is not right. Can you please change it to read?
Baby punya 5 minit siap sudah. Saya punya yang lambat.
So,
Okay.
kapan oras?
Dan
So now, when we speak of, I want to explain to you
aduh.
how the common law system has developed, and then I'll tell you what was the problem. So do you see this writ? So when you want your case to be heard in common law, in the king's court, you must firstly buy a writ.
Tadi saya nampak cakap.
And when you have to buy a writ means it's a legal order, and a writ is basically an instruction from the king telling to the judges in the court, hear this case. This person has a case, hear his case. Like taking a token basically. So when you purchase a writ, you need to purchase the appropriate writ for your case. So there were only selected writs issued by the king. So when your subject matter has got no available writs, the king's court will not hear your dispute. So there's a flaw in the system because the system says you must have a writ. That system we still follow today. We call it as the writ of summon. When you want to sue someone, the first thing that your lawyer will issue to the defendant is a writ of summon. It's just 2 pages of your details, the defendant's details, saying that we want to initiate legal action, legal proceeding for this case.
Masih dalam jam.
Okay, that's a writ of summon to show that you have started the proceeding. So when there were no writ of summon available, the system became so rigid, and then the grievances are not addressed. Right? The public's grievances are not addressed. Where can they go to? Go back to the king. Because he's the leader. Right? So I go back to the king and I want the king now to resolve my dispute. So therefore, the number of cases, alright, number of cases going to the king was beginning to increase. Okay? A student has asked me, it starts with letter of demand. Letter of demand is optional. Letter of demand means you're not suing the person. A writ is where you've decided to sue the person, you've decided to go to the court. So I can choose not to go to the court. I can just ask a lawyer to issue a letter of demand to my client, to my tenant, for example. But if you want to go to the court, the first document is a writ of summon. Okay? Now, so getting back to this history here,
Sorry, Miss Nirmala, can I check? Does it apply in today as well? Like we are like as in we can ask the lawyer to issue letter of demand, but not going to court. It applies. Oh, okay.
yeah, you just have to pay the lawyer the fees to issue the letter. Maybe he'll charge you $2,000. 1,000, depending on the lawyer, how experienced he is. So, for example, letter of demand is where you want to demand another person to do something. You don't need the judge to resolve that. So, you can send a letter of demand. In your letter of demand, you will state, if you don't comply with my demands, then I will want to initiate legal actions. Okay? But sometimes you would have started with your negotiation, for example, you see, your negotiation you would have started and you cannot come up with the terms, you can skip the letter of demand. When you want to go to the court, the first document to go to the court is writ of summon. Okay? Alright, so it's writ of summon now. The history, the origin started long time ago. Then we have doctrine of stare decisis. Now, what is stare decisis? Stare of decisis means, it's a Latin phrase here. It simply means that like cases must be decided. So this is where the doctrine of precedent developed. Once the judges have developed the laws, you have to follow the laws. Okay? So if let's say, like I think all of you know Donahue and Stevenson, right? If let's say now, you have a similar case as Donahue and Stevenson today, you have to follow the decision in Donahue and Stevenson. You cannot follow any other decisions. So like cases must be decided by you. But then you realize that maybe the precedent developed some time ago is not relevant now. Perhaps now you want the judge to change the law. For example, in a domestic violence issue, maybe initially there could be a case where, initially there could be a case or there could be an incident where the court said that, okay, husband, I'm ordering you to stop hitting your wife. That's a developed precedent. What's the decision? Stop hitting your wife. But what if now, after 5-6 years, you realize that the wife wants something more than that because he's not going to listen to you? Perhaps she wants to be separated from him. So we are stuck with the old law. Because once the law has been developed, you have no choice but to comply with these laws. Do you see the problem that we have there? So the stare decisis once again made the system to be so rigid, right? So beginning, this is the start of all the problems. The third problem that we have is damages. Common law, the only form of remedy common law could award is monetary compensation. So when I say monetary compensation means that's damages. But sometimes, again, back to the domestic violence. In a domestic violence, if you were to give me damages, it's not appropriate and it's not relevant for me, right? In a family violence case, perhaps what I require or what I want is separation, right? So giving me the money is not going to address my grievances. So because of these problems, the common law, that was the downfall of common law. The people, the public, begin to move towards the king. So they petition to the king. They want their cases to be heard in the king's council. They want the king to help them to address the grievances. Okay? And the reason why they want the king to address their grievances, because the king was always seen as a fountain of justice. It's a court system which is created by the king. The king was the first judge. Okay? This king, of course, at the beginning, he was willing to accept cases. Subsequently, obviously, you know what is the favorite hobby of the monarchy? Do you know what their hobbies are? Let's see who knows the English monarchy. Correct, very good. Hunting, yes. Hunting is their favorite hobby. Okay? So they want to do that. They want to relax, enjoy life. Right? So, hearing this dispute is like, why are you not doing so much work? I've already developed a system. I have all these people who work for me. I don't need to now concentrate on this. So what the king did, all this petition, he gave it to the chancellor. Who is the chancellor? The chancellor is the man from the church. Remember I said the church was close with the king. The church must advise the king. The chancellor was known as the conscience of the king. He advises the king on religious matters. So the king trusted the chancellor,
哇，你看你肥到这样，
requested the chancellor to now
喂，你看他，你看他，
hear all this dispute. So that is the creation of, look at my last point, the Chancery Court. The Chancery Court is named after the Chancellor because the Chancellor began to accept these cases on behalf of the king. And guess what? The Chancellor applied equity. What is the meaning of equity? Equity means fairness. Equity means justice. So the Chancellor decided cases based on the principles of fairness, based on the principle of justice. He did not apply common law. Because common law is so rigid. You've already developed the law, it's stagnant there. So the Chancery Court looked at the merit of each case and gave a decision. So now you tell me, which court will be more popular? Common law or the Chancery Court?
Chancery.
The Chancery Court became more popular over time. Okay, so this resulted in conflict, which we will discuss after the break. After the break, I'll tell you conflict, what has happened, and the courts that we have today. Okay, you all understand the storyline? Understand the story or not? Or are you all already sleeping?
Yes, thank you. It's very interesting.
Oh, glad that was interesting. Okay, now that you know all this history, you can show off that I'm studying English law. Okay, all right, it's 8:04. I'll see you guys back at 8:25.
Thank you.
Um,
OK，现在这样是有比较好啦，是啊，哈哈，
Mana makanan tanya? Unless you see what the those two basic sheet. Come on.
不可以，他不可以jalan-jalan，因为那个他的那个luka，然后他会 highly sedative kan suppression， so 一定要48 hours， 他一定要 stay 一个 area 而已，然后不可以有lampu那些，一定要dalam dark room。
不可以吗？
他的luka，
啊？
他的luka kena letak ointment terhadap mata.
Oh.
National Day， 那拜五可以送我去 operation。
8月9号。
啊？
Malaysia National Day。
拜五没有 Singapore National Day。
8月9号。
Yes, but then 那个拜五我要拿 full day leave。拜一我拿了 full day， 所以我会有5天照顾他。
Okay.
So betul kan saya bilang tadi pagi dia ada berakan? Lepas makan?
Ya.
Dia nak tu baby dia flush tadi pagi.
What? Saya flash.
Ya.
Saya cakap flash. Ini bukan berak, kencing.
Kencing dia.
Kami berak.
Buat kencing ya lah.
Ya. Come on. Wah, itu besar. 是比较有味道的东西吗？我看，这口的。这样的人谁是我？我有点来。你们都在这里。有别的人说什么好玩？不舒服，你们不了吃呢？啊？你知道为什么不舒服？那刚刚也是用不出来。真不错，你这粉底我可以在那个路上的一起吃过，不错的，我拍照的，你看过这？要不吃完你东西先来玩。
没有这样才玩。用在itu saya ada sedih-sedih dan saya kan kayak ini kan ada break可以一个人在宿舍这么早拿一拿。
帽子楼梯下面。我会有疑念。
小 B， 还没有吃完。
第三波。
Tadi ni kasih naik je dia punya tu. Bukan balik turun kasih.
Ya,因为我这个加三了。
Dah subuh. Okay.
它有它的 fans 哦，有的有的 fans，你不可以讲人家，你还参加，不是人家，那个不是重点，你跟他样子长得不像，你会有你喜欢看的人。
guys, hello again. Okay, let's now continue with the story, our so-called English history. Okay, now firstly, I stopped earlier, just before the break, I spoke to you about how the Chancery Court was created to address the problems that we have with the common law system. And I say the Chancery Court used equity. Chancery Court did not apply common law. Okay, we must be very clear with that. So, which means technically there were two parallel courts in one system. In England, on one hand, you have the common law court, on the other hand, you have the Chancery Court. So, when both these courts exist at the same time, and over time, when the Chancery Court became popular, of course, this made the common law judges to be upset because they felt that they created a system. They were much more qualified than the Chancery because the Chancery was the Chancellor, was the man from the Church of England. And if he has more power, he has the discretion to decide every case on the merit of the case. But whereas the common law judges are stuck with the system, right? So of course they were not very happy about it. So what happened was this, because of these two parallel courts here, this created a lot of tension. Okay? So for example, just to explain to you, can you see this Chancery Court has created their own remedies? They resolved issues not based on common law remedies. They resolved issues based on the Chancery Court's remedies. So these are some examples of equitable maxims and equitable remedies developed by the Chancery Court. Example number 1. He who seeks equity must do equity. That's what it simply means. So when we say he who seeks equity must do equity, the interpretation for that is, if you are seeking for justice, you must have done, your conscience must be clear. If you want the Chancery Court to create you, okay, if you want the Chancery Court to create you, not create you, sorry, to protect you, then it is important for you, okay? It is important for you to also have clear conscience. So if you complain to the Chancery Court that your employer hasn't paid you for 6 months, and then the Chancery Court found out that you have been absent for 6 months and you're still demanding for salary, the conscience are not clear, right? So Chancery Court will not protect you. The second maxim, he who comes to equity must come with clean hands. What is the meaning that if you come to equity, you must come with clean hands? What does it actually mean? So here, it simply means that if you are looking for equity to protect you, okay, you must also you must have done justice. If you have not done justice, so same as he who seeks equity must do equity, right? It's the same thing. Everything, all the maxims, the underlying objective is actually fairness. Now, do you see this case of DNC builders here? Okay. Now, I'm going to give you 5 minutes to do a quick research on the case of DNC builders. I'll tell you what I need you to identify for me so that your research can be very specific. Firstly, identify for me the facts of the case. And then, secondly, identify for me the equitable maxims applied. Now, before that, the facts is one thing, then the issue or issues that we have, and then equitable maxims applied, and then the decision. So, equitable principle was applied in this case. So I'm giving you 5 minutes to do a search. You can either use Google to do a search, or you can actually use your ICT to have a quick read on this case. Okay? So your 5 minutes starts
他想
now.
要打东西给你看还是什么那个 sample 什么东西，我不懂。他讲他一定要 pass 给你。
没有啊，有给他锁匙了啊，我已经给他们一只那个手的锁匙了。我还讲啊，存了那个录音啊，等等等。直接打给他对吧？不要 voice message 啊。拜四早上到，sorry，他刚刚打回来给我，我就打给他了，叫他尽快。他们的拜四会到我工厂，他们把拜四到我厂，我直接送下去了，我直接送下去，拜四。
OK bro，谢谢谢谢。
直接送下去是直接 start to install 还是什么？还是只是送料而已？拜四到我厂，我直接送下去了，我直接送下去，拜四。
所以你拜四会 install 完是吗？拜四会 install 完对不对？
Mana babysitter dia semalam?
Hmm,
Mana babysitter dia?
nantilah saya demo.
Okay, so have you all read the case? Or still reading? Who wants to explain the facts of the case?
You.
What issue was this? Was it a contract issue or a tort issue? Do you know?
Contract.
Very good. This is a contract issue. Payment was successful, could not allow and settle was mutually. Okay. So what was the dispute between DNC Builders and Reese? Mr. and Mrs. Reese. What was the main issue? What was the issue there?
They actually owe the builders a balance amount, but because of the quality of work done, they did not want to pay. And because of this payment, it will lead to DNC to go for bankruptcy. But DNC, maybe they negotiate between them and he accepted the amount of like £300, but pursued to file a claim against the Mrs. and Mr. Reese. So I think this is contract issues lah.
Okay, in essence, you got it right, Azira. So like what Azira said, Mr. and Mrs. Reese, they actually found out that DNC Builders were in financial difficulties. And the work done by DNC Builders, we had no issues with the work, okay? But Mr. and Mrs. Reese wanted to make use of DNC Builders' financial position and say, we're not happy with your work. So they say, we will reduce contract price. So they reduced the contract amount, the balance owing, and DNC Builders, they are desperate, correct? So when they were desperate, they had no choice but to accept it. So they said, okay, if you want to pay me less, I will accept it. So you see, agreed price was higher. Then during the performance of the contract, Mr. and Mrs. Lee says, I'm happy with your work, I'll pay you lesser amount. DNC Builders were under financial constraint, so they said, okay. After accepting the money, DNC Builders decided to sue Mr. and Mrs. Reese for the balance money. So Mr. and Mrs. Reese say, no, how can you go back against your promise? So this case is so interesting because now you understand the facts, right? Mr. and Mrs. Reese, okay, the Reese basically argued that this is against promissory estoppel, which means D and C Builders agreed to accept lower price, hence can't go against their promise. Do you see here? So they were relying on equity. Promissory estoppel is an equity. Promissory is an estoppel is an equity, means that if you actually have made a promise, the law, based on the principle of fairness, says that you cannot go against your promise. Okay? So Reese argued that equity should protect them. But on the other hand, the courts actually said, I think it was Lord Denning, if I'm not mistaken, in this case, Denning says that he who comes to equity must come with clean hands. Do you think Mr. and Mrs. Reese have clean hands? No. The Reese were aware of D and C Builders' financial difficulties. So when you were aware of the financial difficulties, they took opportunity of the financial difficulties. Okay, took opportunity of the financial difficulties, and what did you do? You wanted equity to protect you. how can equity protect you when your conscience are not clean? So the Court of Appeal said the reefs must pay the balance.
Yeah.
You have to pay the balance amount. Equity refused to protect. We cannot use the principle of equity. Okay? So this case is a very good case to demonstrate how the Chancery Court, of course this was used, it's a much more recent case in the Court of Appeal, but I thought this case was an excellent case to demonstrate how the Chancery Court was popular. Because we will just decide on the merit of the case. We'll just use the principle of fairness to decide on cases. Okay? So these are the types of maxims which were developed and created by equity. And then we have remedies, equitable remedies here. So what are the equitable remedies that we have here? Remedies, remember I told you, common law could only award damages. Am I right? But when you look at equity, equity came up with injunction. You still read this type of remedies on newspapers today because equity has survived. Injunction is to stop you from doing certain things. Specific performance is to order you to do certain things. Okay? Then what is rescission? Rescission means we would rescind. Rescind means we would end the contract as if the contract never took place. That is the meaning of rescission. So they have developed various forms of equitable remedies. So when various equitable remedies are developed, obviously plus maxims and remedies, it became popular. Okay? So this is how equity became popular. Now,
Miss Nirmala, sorry, can I check if DNC must DNC prove that Mr. and Mrs. Rees aware of their financial issues, like their financial background?
yeah, you have to. In a court of law, if you made a statement or allegation, obviously it must be backed with evidence here. Right? So perhaps there would have been some evidence. He would have established that they were taking advantage of his financial position, DNC builder's financial position. Okay? All right. So now this tension escalated, went to the king. So it is through this case of Earl of Oxford, as you see. Okay, let me just make this bigger. So it is through this case of Earl of Oxford where the king had to decide if there's a dispute between equity and common law, what shall prevail? And the king says equity must always prevail. And the reason why the king at that time in 1615 say equity must prevail is because equity is based on justice, equity is based purely on fairness. The reason why this Earl of Oxford went to the king's court, king itself, is because some of the members of the public, they will purchase writ, they'll go to the common law court, and once they obtain the decision from the common law court, if they are not happy with the decision, they will go to equity. So the common law and equity, the decision will contradict. So when there's such conflict, which to apply, the king says you always follow equity. So of course this worsened the matter, right? So finally, through the enactments of the Judicature Acts 1873 to 1875, all right, it is through this legislation, equity was merged with common law. So equity merged with common law means all the king's court, the royal courts, became the ordinary court here, and judges today will sit in the king's court, okay? And that means there's no separate court for the crown. The king cannot hear cases in the king's council anymore. All cases must go to the ordinary common law court. And guess what? The common law courts can also apply equity, and common law. Okay, this was done through the Judicature Acts 1873 to 1875. What happened to the Lord Chancellor then? He was promoted from being just a man from the Church of England. He became also the head of judiciary. He became the head of judiciary. And do you want to know something interesting? This position, Lord Chancellor, survives right up till today. Not the same person, the designation is still there. Right up till 2005, the Lord Chancellor was the official head of judiciary in England. Was not only that, it became a very powerful position, the Lord Chancellor. Before 2005, the Lord Chancellor was number one, the head of judiciary, and then was also the Secretary of State for Constitutional Affairs, was also the Speaker for House of Lords in Parliament. He was part of 3 institutions. He was part of the judiciary, executive. The Secretary of State means minister. In UK, ministers are known as Secretary of State. And he was also in Parliament. So powerful, right? The role has become. Okay? It means that there's no separation of powers. Do you know that besides the Queen, the Lord Chancellor is the only person who is involved in 3 institutions? Then what happened was the Constitutional Reform Act 2005 was passed. The Lord Chancellor is today the Secretary of State for Justice. So today, this position is just a political position. Secretary of State for Justice is like our Minister for Law in Singapore. So that's how this role evolved. Okay, you can just do a Google search, Lord Chancellor UK. You can read about the Lord Chancellor. You can read about the history and so on if you want to, okay? So that's how the courts that we have in England today, the courts, that's why you see DNC Builder, it's a court of appeal, but they applied equitable principle. So equity is just one of the sources of law in England today. Like how common law is one of the sources, Act of Parliament is one of the sources. Similarly, this is also one of the, equity is also one of the sources of law. Okay? Okay, so that's the end of the story. Okay, do you know to also signify the historical creation of the Chancery Court in UK, in the High Court, there's Queen's Bench Division. There's another division called the Chancery Division. That is to show the merger of the Chancery Court with the King's Court. Right? There's a Chancery Division in the High Court in England. Okay? All right, so that's all just for historical purposes. Okay, so now let's get back to common law. So common law judges are happy now. They're happy because why? They get to rule. They develop common law. Now they can also apply equity to resolve cases. But today, equity is at the discretion of our judges. Our judges will decide whether equity should apply or not. Okay, so today, which one will be given primacy? Is it equity or common law? Common law will be given primacy because common law has evolved so far, so depth. There are certain areas of law which is just completely governed by common law. Contract law in the UK, tort law in the UK, vast majority of the law, 95% of the law is governed by common law. So the no new equity can be created today, but you can still create new common law precedents. Okay, but you cannot create any new equitable maxims. You cannot create any new equitable remedies because the court has been merged with common law. Whatever pre-existing maxims and remedies we have, that's all we can apply. Okay, so that's just a brief history or origin of the common law system. Clear? So now that we have seen the second part of the lecture, the first part of the lecture is to explain to you what is the meaning of legal system, right? The second part of the lecture was to explain to you the origin of the common law system. Now we're going to discuss about the common law system, the features itself. The features means we're going to discuss the characteristics of the common law system. So first, I think this is self-explanatory. The system is created by the courts. Our common law judges, they are the one who created the common law system. The judges, remember I told you earlier, they developed law in the Westminster and then they expect all the other judges to apply the same laws, right? So the system were created by the judges, the system were also modified by them. So number one, we've spoken about it. But let's talk about number two now. What is number two? You see this doctrine of stare decisis here? So what is the meaning of stare decisis? Like I said earlier, stare decisis means let the decision stand. Do you know, let me also share this with you, at that point or at that time, when stare decisis was, you see the term, the Latin term here, right? So this is where it's a case where English wasn't the official language. Okay, so when I said English wasn't the official language, this is the case where Latin used to be the official language. That is the meaning of stare decisis. Okay, so of course today we give an English meaning to it, and the English meaning that we give to it is known as precedent, the doctrine of precedent. Precedent is an English word, right? So when I say precedent is an English word, precedent is an English word where precedent means past practice, right? Correct? So when we speak of past practice here, it's a case where you follow the previous decision, okay? That is the meaning of precedent here. This doctrine of precedent now is very, very important. Okay? Why is this important? It is important because here, when we speak of this judicial precedent, it became one of the strength of precedent. Okay? So, when I say it became one of the strength of precedent, okay? Today, one of the key features, whenever somebody says that we follow the common law system, it simply means that, okay? It simply means that the key features of the system is precedent. Okay, so how does this apply? How does precedent apply? You would have studied this in bridging, you would have studied this in diploma. Can you explain to me how it applies? Who wants to explain? Who wants to explain? How does the precedent apply? Nobody wants to.
You look at commonalities between the current case they're looking at and the historical cases, and try and apply a similar judgment or take guidance in the judgments that have been passed.
Okay, correct. Yes. So when we look at doctrine of precedent, it's not always about the same facts. You must remember that. This doctrine of precedent is with regard to the same issues. If you have two cases which of the same issues, that's how precedent works. Okay? I'm going to spend some time talking to you about precedent now. Let's look at what Amelia has to say here. Amelia says that precedent also works based on the court's hierarchy. What does that mean? It simply means that the lower courts must loyally accept the higher court's decision. Okay, if you're the lower courts, you must accept the higher court. So you respect the higher court. So the higher court has the function or responsibility to develop precedent. So for example, the high court must loyally accept the precedent developed by COA and UK Supreme Court. Do you see that? Because in terms of ranking, Supreme Court followed by Court of Appeal followed by High Court. This is in UK. Right? So lower courts must loyally accept. So the doctrine of precedent here, it has vertical effect. So the lower courts will accept the appellate court's decisions. The next, precedent also has horizontal effect, which means the court of same level must accept its own precedent. So to give you example here, UK Supreme Court must follow its own precedent, its own previous precedent. So that's the meaning of precedent. So this system of precedent applies in all common law countries. This is a system created by the common law judges. So this is one of the key features of the common law system. Okay, please let me know once you have written this down, and then we're going to have a short discussion. Okay, done? Okay, have you all copied that? Can we get into our discussion? Okay, all right. So now you see I have a question here for you. Can you think of the advantages and disadvantages of judicial precedent? Because I want you to reflect, okay? I want you to reflect. If the common law judges had the power to develop laws, why did they constrain themselves to the doctrine of precedent? It's something that we need to think. We need to reflect on this. Am I right? So I want you to now fill in these for me. Fill in these advantages, disadvantages. Please don't do any Google search. I want you to think independently. So in my lessons for this module, because I said in your research, I say you need to be evaluative, right? So through this activity, I'm training you to think independently and be evaluative. Like I said, see what I just asked you. If common law judges have got so much of hours to develop laws, why did they constrain themselves to be bound by precedent? There must be some advantages, right? Think about it. Then I want you to reflect on the advantages. What could possibly be the disadvantages? Okay, I'm giving you 5 minutes, no Google search, just squeeze your brain and try to think about these advantages and disadvantages. All right? Would you all like to do it as individual activity or group activity? What do you all prefer? Do you want to brainstorm or do you all want to do it individually? I think you can do it individually lah. Right? Yeah. Okay. 5 minutes for you. Okay? Okay, shall we discuss now? It's already 5 minutes. Okay. Now, as you give me the answer, I'm going to help to type here. Okay. So, firstly, advantages of precedent. What do you think is the strength of precedent? You can type your answers here. Certainty of law. That's a very good answer. Correct, Yixing. There's certainty. Let's talk about certainty. Do you know why Yisheng says there will be certainty? There is certainty because when your case goes to the court, you will know that this is the law that the courts will apply. So you are certain. So when there's certainty, Ahmed is right, there will also be consistency. Certainty, consistency comes with another C. There will also be clarity in law. Correct? When the law is clear, let's go in reverse. When the law is clear and you consistently apply the law, the outcomes will be certain for all similar cases. Correct? So at the end of the day, what I'm trying to say, these 3 C's will result in fairness. Correct? Would you agree with me? These 3 C's would definitely result in fairness. Now let's look at what Azira has to say. Azira says it will save time. How does this save time? Because she's right. This can save time on the basis that it can encourage out of court settlement. How does this encourage out of court settlement? You can encourage out of court settlement, okay, on the basis. Okay, you can encourage out of court settlement on the basis that your lawyer will tell you, if we were to go to the court, this is going to be the outcome. So let's negotiate, let's arbitrate, let's mediate. So you finish your case or resolve your dispute faster because you know the law is certain, the law is clear, and you know that there's consistent application, so you and your lawyer can resolve the issues faster. Do you see the other advantage of judicial precedent? Shamila, I've already put the fairness here, so you're right, it creates a system of fairness, so I brought it under the 3 C's, okay? But you're right, wait, I want to see what Azira explained further. It may not please the people. Different judges may have better decisions, but because the decision from previous cases, the judge must follow. Azira, is that a disadvantage that you're discussing now?
Yeah, actually, so it's like it saves time, but at the same time, you know, it also creates like unfairness because maybe different judge has their different opinion on the same case, but they have to follow it. So it's like rigid. Yeah, so we'll discuss the disadvantages later.
Okay. Now, Amelia says institutional knowledge to build upon. Okay, so when you say, so what I will say is the whole vertical effect of precedent. Okay, so that's what Amelia is trying to say. The appellate court judges are much more senior. Okay, appellate court judges are more senior and they have more experience. So when they develop laws here, these laws are well thought. Okay, hence they should establish precedent. So we don't want everybody to develop precedent. So you just follow what the appellate court has to say. Any other points, or shall we move to the disadvantages? Okay, so these are some advantages or strength of the doctrine of precedent. Can I add one more point? We can prevent arbitrary decisions. Do you know what's arbitrary decisions? Arbitrary decisions means you will be able to prevent and you know what Azira says? Azira says you want judges of different views, right? But every time if a judge comes and decide case based on his moral perspective, All right, I think there's going to be so much of confusion, right? So we shouldn't, law cannot be decided arbitrarily. There must be a system, okay? So it's good to follow precedent. Constantine says that the precedent reduces the likelihood of successful appeal. What does that mean, Constantine? Precedent reduces the likelihood of a successful appeal. I don't get that. Unless you're saying that you can prevent unnecessary cases going to courts, you can prevent unnecessary appeals. Yeah, I think that makes sense. Yeah. So that will come under preventing floodgates of litigation. Okay, so I'll put that here. So it can prevent floodgates of litigation. Okay. So those are all the advantages of precedent. Now, let's look at the disadvantages. So the disadvantages, share your views. Others, what do you all think?
Separation of power is challenged because in this case, the judiciary makes and interprets the law.
Okay. Okay, you all can write down all your points here, then I'll see how I can consolidate them. So SOP is one of it, right? You all suggested. Okay. Judicial precedent adds multiple layer of complexity to the legal system. Slow to change, okay. Difficult to change, will need to, okay. So correct. These are the general disadvantages. So firstly, let's talk about rigidity. Now, when it comes to rigidity, what Amelia and what Yisheng says will come under that explanation here. So this rigidity here is to illustrate that outdated laws can continue to apply. So, why is it that outdated laws can continue to apply? Outdated laws can continue to apply because the lower courts are bound by precedent. So when they're bound by precedent, they're going to continue applying this outdated law for a very, very, very long time, unless one case finally decided to go and appeal. So therefore, this rigidity can result, okay, it may result in injustice. All right? So that's in relation to the difficult to change and so on. When a law has been laid, it has been set in stone and becomes binding, which means there is a little room for flexibility. How is this a disadvantage to precedent? People or some may not agree on what precedent actually is in a case and obvious, but uncertainty until final ruling is made. Okay. So let's just consolidate all these views. Okay. So first problem, the key words here is this rigidity, which will result in injustice. Okay. I think one of you also said that there is slow development of laws. Why is it that there's slow development of laws? Because now you need to wait for a case to go to the appeal court. A case has to be heard in appeal court for the appeal court to review the laws and make amendments. So which means it involves a lot of costs. These can be costly. So because the appeal process can be costly, Many will not even bother to appeal, and as a result of it, the outdated common law will continue to apply. All right? Yeah, it forces the system to go backwards. That's a very good point. Okay? Because you're applying the outdated law, right? You're not looking at the future here. So, these are the two sides of the coin. There's advantages, there's also disadvantages. Regardless of these disadvantages, I need you to bear in mind that the common law system continues to apply the doctrine of precedent. The doctrine of precedent remains to be one of the strength of the common law system. So in Singapore, the fact that we apply the common law system, it means that we also apply stare decisis. Okay? All right. Now, before we look at, now we just saw the advantages, right? Before we can look at the other features, we need to examine now, okay? When it comes to precedent here, I said the meaning of precedent means you must apply the previous law developed, okay? So here, what we are going to look at now, what if a judgment is 40 pages? If a judgment is 50 pages, how are we going to now apply everything from this judgment? Of course, the answer is no. It is impossible for you to apply everything found in this judgment. Okay? So here, we have to now appreciate and understand what is the meaning of ratio decidendi. What exactly is ratio decidendi? Ratio decidendi means it simply means that these are the reasons behind the decision. So when I say these are the reasons behind the decision, it simply means that it is because of these reasons. Okay? These were the reasons that we had applied. Okay? These were the reasons that we applied to decide on the case. So for example, all of y'all, have you all heard of the case of Donahue and Stevenson? Have you heard of the case of Donahue and Stevenson? Yes or not? You have, right? Everyone can confirm? I can use that as a case study here, okay? So, Donahue and Stevenson is a case where Mrs. Donahue decided to sue the manufacturer. So the issue here is the manufacturer responsible towards the consumer's losses? And the court said yes. But what was the law that they applied? Can you tell me? What was the law applied in the case to say that manufacturers are liable towards consumer? Yeah, tort law, but let's be more specific. Of course, they applied negligence. So yeah, duty of care is correct. What was the test they established in duty of care here? Not remoteness. Yeah, Jack, you're right. Neighborhood test. The neighborhood test was the first time established in the case, right? Do you remember? It is through this neighborhood principle the courts established that all manufacturers owe duty to consumers. Correct or not? All manufacturers owe duties to consumers. You must treat your consumers like your neighbor because these are the people who are affected by your action. Do you know the neighborhood test became the test for duty of care for so many years in the UK? Even till now, the essence of the neighborhood test is still applied in UK and Singapore. The foreseeability and the proximity element is applied, right? That is the ratio of Donahue and Stevenson. That case of Donahue and Stevenson is still a good law because of the test applied in that case, the law applied to decide or determine the liability. Okay, so this is how you must appreciate and you must understand the precedent applies. We will only apply the ratio in a case. We will not be concerned of all the other aspect of the judgment. Okay, all the other aspect of the judgment is, to be honest, not relevant to your case. Because sometimes when you look at a judgment, what you can find in the judgment is the courts will discuss about the facts of the case. So when the judges discuss the facts of the case, so you need to bear in mind, of course, I don't want to apply the facts in my future cases, right? The facts is not relevant. So when the facts is not relevant, of course, in this instance, that part of the judgment is not relevant. All right? Only the part of judgment where you have applied and discussed the law, that aspect of the judgment becomes the binding precedent, basically. I hope this is clear here. Okay? So that is the ratio. If you contrast the ratio, occasionally what you can find in judgment is the obiter dicta. So what is the obiter dicta now? Obiter dicta means these are by the way decisions. Okay, so when I say by the way decisions, these decisions are not binding decisions. You must remember that. These are not binding decisions because when we speak of these decisions are made by passing, or these are discussions of laws made by passing. So when I say these are discussions of laws made by passing, the judges merely decided to discuss these laws here. Okay? So in that context, all right, in that context, you must bear in your mind, okay, in that context, you must bear in your mind, obiter dictum is a by the way discussion. So when it is a by the way discussion, we should not follow this law strictly. When you should not follow the law strictly, when you can't follow the law strictly, okay, in that context, obiter dicta, what we say is something unrelated. Okay, so for example, I just want to give you in a hypothetical example, how does ratio and obiter apply? Look at this. Actually, not hypothetical, real example here. Let's look at the first case which was decided in 1987 here. How? That time it was House of Lords. Today it is known as UK Supreme Court. Okay, the name of the case or the court has been changed. Alright guys? So in this case here, it was a case in relation to murder. The ratio of this case. So this is a case where there was murder. So the accused raised the defense of duress. The accused said that duress means forced. So he said that he was forced to commit this crime. If he did not commit this crime, he was threatened by this third party that the third party will harm and hurt the accused. So out of no choice here, he committed the act of murder. So the courts now said that duress cannot be used as a defense for murder. Why is this the ratio? Because on the facts of this case, this is a murder case. This is a murder case, and in this murder case, the courts established the principle that murder duress cannot be used as a defense for murder. Then in the same judgment, it's a murder case, right? The courts took the opportunity to illustrate that you cannot use duress even in a case of attempted murder. Okay, even in a case of attempted murder, duress cannot be used. Now, it's a different offense. Do you realize that? Attempted murder and murder is a different offense. Murder is a much more serious offense compared to attempted murder. So, of course, this is not an attempted, the accused was not charged for attempted murder. So, when the accused was not charged for attempted murder, any discussion in terms of attempted murder is of course not relevant to the case, right? Okay, so that's the reason why duress cannot be used as the defense for attempted murder, which this law was not applied to the facts, because the law is, the case is about murder. So the ratio is duress cannot be used for murder, obiter is basically you cannot use it for attempted murder. In 1992, subsequently, okay, if you look at this case, in God's is the same thing. It's a case of duress. A third party got this accused and, basically told the accused that you have to hurt some other persons here. If you don't hurt them, I'm going to hurt you. But what happened here was, the accused in this case was only charged for attempted murder because the victims were still alive. Okay? The victims were still alive and were charged for attempted murder. So now what happened here was, you must follow the precedent in how, correct? But if you see what the courts have done here, the courts have decided to apply the obiter dictum established in how. Because the courts thought that this is a House of Lords. The House of Lords obiter dicta creates a lot of weightage. Okay, so when you look at the obiter dicta here, because it comes from the highest court, we must give importance to it. So therefore, when you look at the system of precedent here, it's important for you to appreciate and understand, sometimes even obiter dictum are so significant for the development of the law. Don't you agree with me? Obiter dictum is so significant because if you can prove that an highest court obiter dicta is relevant, the courts will actually, future courts can actually apply them. All right? So in this context, it's so important for you to appreciate that obiter dicta in some circumstances may have some weightage to it. Okay? All right. Now that we have seen how the doctrine of precedent actually works. So when I say that how it actually works, it is just to illustrate and highlight, or rather to explain to you the position of the law here. So when we speak of the position of the law, precedent can sometimes have some flexibility because of this obiter dicta. The courts can say, okay, we'll follow the precedent, but let's look at the obiter dicta instead of looking at the ratio decidendi. So this is how there is still some element of flexibility in the or within the common law system. Okay, it's very unique. If you really get into deeper system here, it's very unique. So I did explain to you about the vertical effect. We also spoke about the horizontal effect earlier. Okay, so vertical and horizontal effect. So I don't have to explain that. Next, so what I've covered two features of the common law system. A quick recap with regard to the features of the common law system. So when we speak of the features here, what I did so far, I did explain the system was developed by common law or by courts. Correct? Number 2, I did explain that it is based on precedent. Then we spoke about so many things about precedent, right? Number 3, the third feature is judges are able to develop laws. That means this common law system do allow judges to make law. So we're going to talk about judicial lawmaking now. Okay? Do you have any questions that you would like me to address or answer at this moment? All okay? Okay. Now, let's talk about judges as lawmakers. Very important for us to address this issue. When we speak about judges being the lawmakers, it's important for you to appreciate, it's important for you to understand that judges must have the ability to make law because this system was created by them. And also, when you look at the King's Court developed at a time when there was no acts of parliament. Correct? It developed at a time where there were no legislations. So the courts had to create their own laws, which we can't blame them for creating laws. They have to resolve issues, right? So that powers to create new laws, establish new precedent, continued to exist for a very, very long time. And in fact, it exists till today. Like I mentioned earlier, many aspects of common law that we have today, it is still, is developed by common law judges. The example that I gave you, something that all of you can relate to, would of course be tort law. When you look at the tort of negligence, for example, the tort of negligence is largely governed by common law judges. The entire area of law was just developed by common law courts. So when these contract law, negligence were all developed by common law courts, so this is where you have to appreciate judges continues to have these powers here. All right? Okay, now let's talk about examples of cases where judges have the ability to develop laws. Okay? Let's talk about the case of Crown against R. Now, some of you may be familiar with the case of Crown against R. So, when I say some familiar with the case of Crown against R, what is this case about? This case is with regard to marital rape. So in this case, the wife had complained that, in this case, the wife had complained that the husband had raped her. So these two, husband and wife, they were separated, not by law, they were not divorced yet. So their marital relationship is, they were still married. Okay? So the couples were still considered as married couples. So when I say the couples were considered to be married couples, she complained that her husband has forcefully had sexual intercourse with her. But the problem in this case is, in Crown against R, the common law precedent in this case was very interesting. In Crown against R, the common law precedent was based on the concept of family law, which is once you've married a man, the law deems that the wife consents to everything, including sexual relationship, which means the man does not need to obtain her approval. Okay, that's the case of Crown against R base. I mean, that's the precedent. So this lady now, when she went to the court, the law is against her. The 100-year-old precedent shows that husbands cannot be guilty of rape in marriage. But this lady, she fought, she went to right to the highest court. And when she went to the highest court, the judges had to review back their own developed precedent. And they say, oh, the precedent that we developed is outdated. They, in fact, in this judgment, the courts commented that the social standing of women has evolved over time. The status of women has changed. So when the status of women has changed over time, saying that in a marriage, women consents to everything, the courts thought that that is not the modern concept of marriage. Those who are married, can you tell me, what is the idea behind marriage? What is the idea behind marriage? Who can tell me? How do you perceive marriage as? Ha ha ha. Start family and have kids. No. Marriage is seen as equal partnership, right? I mean, it ought to be seen as equal partnership, right, these days. Because again, why? The precedent, which was developed back then, is at a time where women did not have the same social standing as men. But today, women have same social standing as men. Correct or not? So in this case, the courts actually spoke about the social status of women, and they said we're going to depart from our precedent. So Crown at R is a very good example to show that when there is outdated decision, the courts will be willing to depart from their own precedent and develop new laws. So what was the new laws that they developed here? The new laws that they developed here was to establish, okay, they basically established that husbands can be guilty of rape. So when I say husbands can be guilty of rape, this is the law that they have developed basically. Okay? That's one case law example to help you to understand how the courts have established the doctrine of precedent and at the same time develop a new principle. Okay? Now let's look at the case of Brown. What is the case of Brown here? In this case of Brown, okay, it's a different type of case here. In Brown, it's a case involving a group of homosexuals who had engaged in sexual violence. So which means they gain sexual gratification through violence. And I'm not sure why this event, which took place between all adults, consenting adults here, all of them agreed to this act. None of them were forced to this conduct or these actions here. So when they were not forced here, unfortunately what happened, these recordings were somewhat passed on to a police officer. A police officer caught hold of these and decided to arrest all these adults who were involved in this sexual violence, and they were all charged pursuant to Offences Against Persons Act 1861. This is a statutory law, and according to the statutory law, if you were to commit, assault, that means you hurt a person in these circumstances, this is regarded as a criminal offense. But that's not the issue. We want to look at this case on the basis of how did judges develop law here. In this case, what was so interesting is the courts in this case had to decide on the defense of consent. These group of adults argued that, these actions were by consenting adults. Since these are by consenting adults, we should not be guilty of the crime. So technically, the courts had to decide, can consent be accepted as a defense for this case? If a person is charged for committing actual bodily harm, can you rely on the defense of consent? In this case, the court said can't. The judge actually said cannot. And on what basis? The defense of consent, consent was not a defense found in OAPA. What is OAPA? Offences Against Persons Act. So what is interesting here is the accused, they were all charged pursuant to the OAPA. Defendants were charged pursuant to OAPA, but the defense is based on common law defense of consent. So this is how common law can be sophisticated. Sometimes it can be sophisticated because a person is charged under the statute law, but the defenses that you want to rely cannot be found in the statute law. You will actually rely on common law defense. So when you rely on these common law defense, the judges will have to decide if these defenses are applicable or not. In this case, the courts actually say, no, the defense of consent cannot be applicable. Why is it that they say the defense of consent is not applicable? The courts thought that there is no social utility for consent to be a defense. There must be social benefit. So this principle was actually established in this case. Prior to this, it was not discussed in any case for there to be consent, there must be social benefit. Do you see here? So this is how common law is able to develop as and when it is necessary for them to clarify the law. So my argument is, if somebody tells me that the common law is a rigid system because we follow precedent, I will rebut the point and say the same system which ensures we follow precedent, do you realize this is the same system which allows judges to develop laws? You agree with me? So therefore, we have flexibility in the system by allowing judges to depart from precedent as and when it is necessary. Correct? That doctrine of precedent is so important because we want to ensure that we comply with stare decisis to have certainty. In any legal system, we want to have certainty, right? But of course, whenever there's a need for us to make changes to the system, our common law judges will not hesitate and they will definitely make changes to the system as and when it is required. So with that, I want you to appreciate how interesting is this system? Do you agree with me? So interesting, right? It is so interesting because the system, on one hand, focuses on rigidity. On the other hand, there's flexibility because you can depart from precedent and you can develop new laws. Do you get that? Do you see what we have studied, what we have covered? Do you get that or not? Do you all understand? So the unique features is there's rigidity because of stare decisis. There's flexibility because you can depart from precedent only in exceptional cases, not all the time, and judges can develop new laws. So the system gives you both. And let me tell you the secret ingredient of the system here. The system has survived for centuries because of this rigidity and flexibility. If the system only gives you rigidity, the system wouldn't have survived, you know. If the system only gives you flexibility, we would have made changes to the system by now. It gives you both. Clear here? Okay, so for rigidity, one case law example that I can give you is Donahue and Stevenson. The law still remains as a good law today. For flexibility, you can use any one of these two cases on my screen. Crown against R or Crown against Brown can be used. Okay? Do you have any questions? Do you have any questions that you would like to ask me? No. No. Everyone's fine? Okay. Now, the next features of the system is the adversarial system. But what I will do, today is the first class, so I've given you all the historical reasons and so on. So I'm going to ask you to read up. I'm going to give you homework. When am I seeing you again next? Can I just check? When am I seeing you again next? Do we have class next week? I'm sure we have, right? Right? So I want you to do some prior reading on these next Tuesday, okay? So I want you to do some prior reading on these adversarial system, okay? And then if you see what we'll discuss, the system I've already explained to you, the features, and then the three pillars, and towards the end is very quickly just to go through the Singapore system. But I have got a homework for you. The homework is, let me show you what's your homework, okay? Okay. Go through seminar 1. You see the seminar 1 here? This is a pre-seminar activity which I'll be doing with you next week. Here, read a common law case of your choice and illustrate what was the precedent applied in the case, or you can also tell me what was the law that they developed in that case. It can be any case. Next Tuesday, no class. Next Tuesday is public holiday also. Okay, you can read any case of your choice, but I want you to share with me the case that you have. All right, so you must come prepared. So wait, let me check when is your class. Next week I don't have class with you. Oh, we have class on the following Tuesday, 19. 19 we have class what? 19 July. Your timetable says 19 July is our next class. Yeah?
Yes.
Yeah. Okay. So now, so you understand now, this is the pre-seminar activities here. Now that we have completed some of the discussions here, I think you can answer question 1, 2, 3, 4. 5 is evaluative. You think on your own. I don't want Google answers. I'm telling you, really don't want. I mean, sometimes when you type your answers, I know which is Google and which is your right. Short answers also. Okay, so please prepare for question 1 to question 5. Okay, and then I want you to share with me this question here. Okay, so that's your homework. Since we do not have class for at least next 1 week or so, I want you to work on this. Are we clear that I've given this homework? Okay. No, this is just short answers only what. So no word count all. Just short answers. This is seminar question for us to discuss. You don't have to submit your written answers to me. You don't have to email your written answers to me. Come prepared for the discussions for next week. Okay? So next week we will complete our lectures for seminar 1, which means we'll go through the case note discussion, 4 cornerstone, the pillars of the state, all of that we will complete with the seminar questions as well. Okay, guys? All right, before I mark your attendance, do you have any questions that you want to ask me or you would like me to address? Anyone with any questions? Jason, it's on the 19th, Jason, not next week. The next class is on the 19th. Okay?
Ms. Nirmala, so there was a portion on formative in the website.
Correct. So your formative, let me address that. So your formative is only for, as you can see, one of your here. Okay? So for assessment 1, you have formative. You do not have formative for assessment 2 and assessment 3, right? Because this is an essay question, your formative, you must only write 700 words, word count. You don't have to produce the entire essay, and you will have to upload it in your Kaplan Canvas, and I will share feedback. What's the difference between summative and formative? Of course, at this stage, I think all of y'all will know, but let me just explain. Formative is not graded. Formative is not graded means it is for you to prepare a draft and send it to us, for us to look at your draft and give you a general feedback on what or how can you improvise your work here. So you can create an essay plan, 700 words. You can write it in point forms, all right? And please use all your BCU website, various databases to conduct your research on LESPO here. You can submit in Word document here. Your student number must be there. Always back up your formative and summative. All right. So let's now look at the deadline for your formative. So your summative is on 22nd October, am I right? Correct? So your formative, I would give you somewhere in August. So obviously by then we would have covered the lectures on this. So maybe I will give you, let's select a date. I can give you a date now. For August, I will give it to you on August 19th. It's a Friday. Okay, so your formative deadline is August 19th. Okay. So I repeat, this is not graded, formative. You are encouraged to do your formative, so at least you get an idea of what you're going to prepare. Yes, Yisheng, do you have a question?
Hi, Nirmala, sorry. Just to clarify, for assessment 3 is the deadline for the reflection also on 22nd of October, or because it's not stated on the document itself.
Correct. So Jinling brought this to our attention earlier, and then I did mention earlier that I'm going to check with Kaplan on the date for your skeleton arguments and your reflection, and I'll get back to you in our next class on that.
Okay, thank you.
Okay, but it's not anytime soon. It will be towards the end of the course for sure.
Okay, got it. Thank you.
Alright. Anyone else? Any other questions? The lecture slides file title 3 for cornerstone is empty. No, it cannot be empty. What? I think they have got some issues there. Is yours empty? Can everyone check? This one there? I think they've got some error. So there is a file with title, but there is no slides. So weird. Send slides here. I don't know why. I will upload this in my Google Drive. So what I will do, I'll upload this on my Google Drive together with the Oscola referencing, and I'll share the link in our next class. Okay, let me look for my Oscola referencing. So in the next class, I will just share it with you. Okay? And just check if there are any other slides which are blank or empty or whatsoever. Then you can just drop me an email. I'll just inform Kaplan as well about it. All right? Thanks, Lucas. Thanks for checking. Okay, so I'm going to call out your names. Please let me know if you're present. Number 1 on my list is Loshini. Is Loshini here? Loshini. Not here. Then Constantine is here. Rajaraman.
Present, madam.
Brandon. Brandon not here. Hu Xiayo.
Present.
Tristan Low.
Present.
Shankari.
Present.
Edison.
Yeah, here.
Lo Yishan. SHAN. Not here. Okay, Jaslyn.
I'm here.
Lo Yisheng.
Yes, thank you.
Prem.
Yep, here, madam.
Lucas.
Present.
Lo Tieng.
Present.
Li Jinling.
Present.
Abulim.
Yeah, miss.
And then Sadiq. Sadiq is present. Okay, take care, Sadiq. We come in. Andrew? Andrew? Yeah. Emilia? Noel, Michael? Ivan?
Present.
Ibu?
Yep, present, thank you.
Roslyn?
Present, thank you.
Azira?
Yeah, I'm here.
Shamila?
我们有看到那个公司嘞，我是去那边一天看看，这样就走了咯。也没有什么特别啦，这样子。
Sophia?
就因为我去过厦门的，
Here, I
真的
got your
是差别
message
很大。
earlier.
我
Jason,
有看到那个
Sophia.
双人拍的
Jason's also here.
把 Neolith 的展也是很 simple 的，
Here.
它
Hamid?
的 backdrop 只是用 Neolith， 剩
Jasmine?
下的全部都是
Jasmine,
用别的料。
Just has COVID, so she's sick. Yeah.
Rizwan is here.
这样沙巴
Let
什么
me
颜色
now
可以
read
走啊？
out the
沙巴。
absentees. I've got 4
因为现
absentees.
在哦，你看啊
Jasmine,
，Pacton 的 Neolith 的加起来，
Lo Yishan, it's the
会比较高
LOW Yishan,
我
and
不懂
then
沙巴那
Brandon
边
and
啊
Loshni.
加起来
Right?
那个
So
价钱会不会
yeah,
更
correct.
高？
29 of you.
还有运过去是那种
Okay,
运
guys,
输费也是不便宜。
Do your homework, do some reading slowly, gradually, and I'll see you all on the 19th. Okay? Good night.
Thank you.